Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about video evidence in sexual assault trials. Cases that should have gone to the Supreme Court of Canada, but didn't. In the case involving A.L., the sexual assault that was at the center of the charge against him was captured on video. Mr. A.L. alleged that the sexual activity in question was consensual, whereas the complainant alleged that it was not consensual. The video was not played as a part of the Crown's case against Mr. A.L., but Mr. A.L. wanted to use the video for the purposes of cross-examining the complainant. He was not permitted to show the video to the jury. However, the judge did allow him to cross-examine the complainant on portions of the video without showing it to the jury. At the end of his cross-examination, Mr. A.L. sought again to admit the video into court and as evidence to be shown to the jury. The judge again denied this application, and this became the issue in court. The judge relied on some provisions of the criminal code that prohibit the admission of certain types of evidence in sexual assault trials because they tend to undermine the likelihood that somebody is going to be convicted by propagating myths about the behavior of individuals who are the victims of sexual assaults. These are known sometimes as the twin myths in sexual assault cases. There's also rules against the admissibility of other types of documentary evidence in sexual assault cases and protecting the dignity of people who are coming forward before the court. But at the end of the day, isn't a court of law a place where the truth is to be determined? And if the task of the jury is to determine the truth of a matter, then wouldn't an objective record of the actual incident in question be the most probative evidence to put before the jury? And although it might be embarrassing or otherwise troubling for the complainant to know that everybody has seen this video, if it was a case where the allegation was that the sexual activity was consensual, then the circumstances surrounding that activity and the things that led Mr. A.L. to believe that it was consensual during that activity and immediately before and after that activity are the types of things that absolutely the jury should see. So this case raises very important issues. How do these provisions of the criminal code, which have in recent years become much more strict than they were before, how do they play against the right to be presumed innocent and the right to make full answer in defense and the right to put your evidence in your case before the jury if you have probative and compelling evidence that is otherwise inadmissible under this section? It's unfortunate that this has to be the type of case where this type of issue is brought up, but at the end of the day, doesn't the truth-seeking function of the court have to take precedence over anything else? And doesn't the need to allow the accused to make full answer in defense to one of the most heinous charges in our legal system have to be something that the court considers with the most serious gravity? This is the type of thing that the Supreme Court of Canada should have intervened on to give better direction for people as we more increasingly have technology available to us in times where sexual things are happening. It's more and more likely that we're going to have contemporaneous records of some sort of the sexual activity. And so aren't those records ultimately going to be relevant, and shouldn't we have a framework now for how those records are going to be admitted and not admitted and used as our technology develops? Shouldn't our legal system develop to adapt to it in a way that still protects the golden thread of the justice system by maintaining the presumption of innocence? These were all issues the Supreme Court of Canada couldn't have commented on, and unfortunately they missed that opportunity. This means that it's going to take another sexual assault case, another potential conviction in these circumstances, and another complainant who has to go through all of this before the Supreme Court of Canada is going to chime in and let themselves be heard on the way that these applications should take place and whether this type of evidence should be admissible. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.